I do think that the court is going to be able to make a distinction here, which, for better or for worse, I think is going to draw that fight out a little bit longer. What do you think? We are the Armed Attorneys. Today we come with an exciting update. We're talking about the Cargill v. Garland case. This is our bump stock case out of the Fifth Circuit Court of Appeals. This has nationwide implications. There's a lot to this, talking about bump stocks. Going to be talking about FRTs just a little bit and what the path forward looks like. But before we begin, show your support for the Second Amendment by hitting that like button. And today's show is brought to you by our friends over at Acre Gold. Here's something new. You know how the price of gold has been all over the place lately? Now there's a new way to buy gold through a company called Acre. You pay each month, and once your gold stash reaches a price of their gold bars, they discreetly ship Acre Gold to your house. And just recently, they introduced a new $100 a month subscription for a 5-gram gold bar. Acre lets you invest in physical gold without coming out of pocket all at once. They're also a fantastic hedge against inflation, which we've seen all over the place with gas, lumber, and food prices. So check them out at getacregold.com. Thank you to our friends over at Acre Gold. Now, today we're talking about this huge bump stock case, Cargill v. Garland, out of the Fifth Circuit Court of Appeals. This case number 20-51016. Now, the Fifth Circuit Court of Appeals has issued a mandate in this case.
As folks will remember, this opinion came down in January, where the Fifth Circuit Court of Appeals, in a 13-3 ruling, ruled in favor of Cargill, basically saying that the ATF exceeded its regulatory authority by expanding the definition of machine gun to include bump stock.
And effectively, what the ATF did here is they modified the Code of Federal Regulation. This is under the Trump administration, 2018. And the definition for machine gun under the Code of Federal Regulation came out of sync with the United States Code. Big deal there because the Congress writes the United States Code, government agencies, CFR. You would think our elected officials, their version of events would control.
Well, of course. And that's basically what the case was about. Now, the mandate that was issued yesterday basically says that the ATF decided not to engage in any other request for review or direct appeal to the Supreme Court. And so the Fifth Circuit basically said, we are done with it. They sent the case back to the district court with an explicit order that the district court had to act within the opinion that was released last month.
Yeah, so we have the Western District of Texas. They said, go ahead, ATF. You can change the definition Congress wrote. Went up to the Fifth Circuit. They reversed it, sent it back down. Now, the immediate after effect, I guess the question that a lot of people have are bump stocks legal in the Fifth Circuit? We're talking about Texas, Louisiana, Mississippi.
Yeah, and this is quite the contrast, because it's just simply a matter of due process that you cannot have a federal criminal law that criminalizes conduct in the state of Oklahoma or Alabama, and yet does not criminalize conduct in the states of Texas, Mississippi, and Louisiana. And so this is exactly the sort of thing that the Supreme Court ultimately will have to resolve. It just appears right now that the ATF has made the conscious decision to not ask the Supreme Court to use this case to resolve it.
And that's very interesting. And here is the Fifth Circuit Court of Appeals. This is the mandate. It's ordered in a judge that the judgment of the district court is reversed and remanded to the district court for further proceeding in accordance with the opinion of the court. Now, just as you brought up, we got this in the Fifth Circuit. You think that it's a strategic decision not to appeal this case by the government?
Yeah, I do. I think that the ATF is basically buying time with this, either in the hopes that that Congress will actually take it on itself to write a law regulating bump stocks, because what's important here is that this decision was not made on Second Amendment grounds.
No.
So the Fifth Circuit didn't say the regulation of bump stocks violates the Second Amendment, which if they would have, that would have even foreclosed the ability of Congress to pass a bump stock ban. But since they did it on administrative grounds, what the ATF has done is they are going to use this, I believe, to lobby Congress to say, you need to regulate bump stocks, while at the same time not upsetting the overall administrative apple cart.
Yeah. And let me do this, looking into your crystal ball, or if you had to make an educated guess, let's assume Congress went and decided to redefine machine guns and their new definition would sweep up bump stocks. Do you think that that would be a violation of the Second Amendment under, the New York State Rifle and Pistol Association v. Bruin decision?
Well, certainly bump stocks were not around when the Second Amendment was written. And so that's going to be kind of the argument, I guess, in favor of upholding this. But what they would do, I think, is look at just accessories in general, because that's what this is. It's simply an accessory. It has no mechanical pieces. It doesn't actually, it's not actually a gun. It's just simply a device. And in fact, with regard to bump stocks, as opposed to force reset triggers,
Yeah, I knew that's where you're going.
it's not even a mechanical device. It's just an innate piece of plastic.
So, and I think that raises the question, how does this affect FRTs? We see this fight going on in circuits all over the United States. I think that the court is going to be able to draw a distinction here, just as you illustrated, the bump stock, accessory, inanimate, whereas the FRT, I think, is a little bit more nuanced. And while I don't necessarily think it falls under the definition, they didn't change the definition to make FRTs fit into this. They're using the existing definition of machine gun to say, hey, these things are illegal under federal law. I do think that the court is going to be able to make a distinction here, which, for better or for worse, I think is going to draw that fight out a little bit longer. What do you think?
Yeah, and because the FRT is a mechanical device, I think that's going to be the distinction. However, I think as a mechanical device, they may look at it in terms of just the advancement of firearms technology.
Yeah.
And I think it stands a really good chance that the FRTs stand a very good chance of being protected under the Second Amendment, because they would have to go back and say that the Second Amendment doesn't protect advances in gun technology. And I do not think that that's a feasible position.
Yeah, but I think it's an interesting distinction. One, we're relying just kind of on some good criminal law and kind of procedural mechanisms, on administrative procedure. The other one we're looking at with FRTs, a violation of the Second Amendment.
And I think that it is disappointing, I kind of believe, in that the ATF is kind of taking this course of cowardice and not going to the Supreme Court, because I really like this Cargill decision and what it does to the administrative state. And it really hobbles the administrative state. And for those of you who are very suspicious of the activities of administrative agencies like I am, you want to see the administrative state hobbled as much as possible. And so I would love to see the logic of Cargill versus Garland expanded to the entire United States and not just limited to this specific instance.
I think it's a little ironic that you talk about ATF cowardice on the anniversary of the Waco siege. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And I'll tell you, YouTube is monkeying around with us. If you don't have notifications enabled, we haven't asked y'all to enable those before, but that seems to be their kind of new kick. They seem to be hiding our videos from folks, but make sure you have notifications enabled. And we want to know what you think about this. Do we think that the regulation of bump stocks and FRTs, does that violate the Second Amendment? I'm interested to hear what y'all have to say. And until next time, we're the Armed Attorneys.
As always, more guns equals less crime. Go out there and buy yourself a gun.